The investigation of Officer Darren Wilson is taking too long. Just hours ago, Prosecutor Bob McCulloch told me a grand jury decision could come by early November. I asked him why this process is taking so long.
Well, here's what happens is in most situations, and this is different, this is being handled differently than most cases. We take any homicide case, murder cases, anything involving a death, go to the grand jury. What happens usually is that the investigation is completed.
But that's not the case here. So the grand jury is hearing testimony from the witnesses directly instead of through detectives.
There has been some call that, you know, I'm not going to be fair and impartial, and so I don't think those are legitimate claims, but again, an abundance of caution, by putting on all of the evidence, by putting on the witness, there isn't anyone who can legitimately say, well, you know, yeah, the cops came in and said this, but that's not really what the guy said. And now we've got the guy sitting there saying, you know, here's what I saw.
This is also a strange situation because Bob McCulloch is using a process he never used before, which is to present all of the evidence to the grand jury and to let them choose.
Well, the thing is this. The grand jury doesn't need to hear all the evidence, and normally we don't do that. You don't even necessarily present all the evidence at trial.
And so they go to the grand jury and say, this is what we think the charge is, here's the evidence. Do you think there's enough evidence to move forward?
At the grand jury level, it's just a probable cause hearing. It's not a determination of guilt or innocence. So all you're doing is just presenting enough evidence to say that you have probable cause to move forward.
So in a normal grand jury, the prosecutor would decide what degree of homicide they thought they were looking at, and they would present the case to the jury with an eye on getting a certain charge.
But normally they would bring in the detective and one or two witnesses, and the grand jury would vote. It would be done in a day. Because remember, what the prosecutor's office is trying to do is to get a quick indictment so that they can move on to trial.
Right. So they, in this instance, they're getting all the evidence. Evidence that proves guilt and evidence that doesn't prove guilt. So that's what they'll use to make their decision.
Now, when you say that you're going to give the grand jury all the evidence, that is a tactic that prosecutors use to confuse the grand jury. They've been doing this long enough to know that if you overwhelm the grand jury with evidence, it'll be difficult for them then to go ahead and make that decision.
In a typical grand jury, they only bring in really evidence of guilt. Would normally happen is the prosecuting attorney's office would look at the initial information that comes in and say, you know what, this looks to me like, for example, an arson. So let's charge the defendant with arson. Let's take him into custody and get it in front of the court. So they would have the police swear out a probable cause statement, and they would charge the person, and that person would be arrested, and if it was a serious case, they'd be held in jail or forced to make a bond until the grand jury returned with their verdict.
Under normal circumstances, people are charged by information, and then the case is sent to the grand jury for confirmation, which means that the person is normally already in custody, has been charged, and generally given a high bond before the case is sent to the grand jury.
So it's very unusual that instead of charging someone and then taking the case to grand jury, Bob McCulloch, by his own admission for the first time, is saying, well, let's have a grand jury look at everything instead. My first thought was, boy, I wish my clients had been given the opportunity to have all the evidence presented at their case to the grand jury. And boy, I wish my clients would be given an opportunity to testify at a grand jury and tell their side of the story.
It's very rare that you even bring a defendant in at the grand jury level. And most of the time, I'm going to tell you, quite frankly, when I was a prosecutor, when we brought a defendant into the grand jury, that was because we didn't want the case issued. And that was the reason why we were allowing the grand jury to hear the defense side, because we don't have an obligation at that stage to present the defense or cross-examination, because our goal, remember, we're the prosecutor's office, and that's to get an indictment. So normally when prosecutors want to get rid of a case, they will bring the defendant in and let them give their side of the story, which then the grand jury is able to hear that, and most of the time after that they will make a determination not to true bill.
I've spent my whole career as a lawyer for poor people, and I resented the fact that someone was being given opportunities that my clients would never be given.
Also, the thing that you have to take into account is that this grand jury has been hearing cases and probably heard from Ferguson police officers at this point. And so they already have a reasonable understanding of the credibility of those police officers. And by him testifying for 4 hours, now every bit of evidence that they hear after that is going to be through the lenses of his story, because they're going to be thinking about what did Darren Wilson say as they listen to these witnesses. And the thing about it is that he's had an opportunity to hear all the stuff in the media, to know what's out there evidence-wise, so he can then conform his story to fit what's already out there.
That they would then introduce the jury instruction on justified use of force and say, all right, the law says that in certain circumstances police officers can use deadly force, and these are the circumstances. So include that when you're making your deliberations.
The thing about Darren Wilson is that he came in and testified for 4 hours. Now, as a defense attorney, I'm not going to let my client come in and testify 4 hours and I can't be in there unless I feel very comfortable about how the prosecutor is going to handle my client while he's in there in the grand jury. That's a long time. Even if you have a client testify, you generally want them to get in and out quickly, because you don't want them to say too much, or you don't want them to say anything that's going to incriminate them any further. You know, I'm sure witnesses have said that Michael Brown had his hands up. Well, if I was representing Darren Wilson, I'd say, yeah, he had his hands up coming at me, not hands up surrendering. You know, that's what any good defense attorney is going to do. So I'm sure he went over everything with him before he went in and testified at the grand jury and made sure that they had a possible response for any question that could have possibly come up.
Having a father who was killed would affect Bob McCulloch. I mean, I couldn't even really speculate on that. I can say this, his office works every day with the police. They are dependent upon the police to make their cases. They vouch for the police every time they file charges. Bob McCulloch has a family full of law enforcement officials. So he did have a very close relationship to the police when this whole thing started. Not necessarily any closer than any other prosecutor would have had, except that these are his police. These are the police he works with day in, day out, and has for as long as he's been in the prosecutor's office. For that reason, I think that this process would have had more credibility had he let someone without that personal relationship with the police handle the case, but he chose not to.
You're looking at the case, but the reality is that the grand jury is just an arm of the prosecution. They do whatever the prosecutor says. If the prosecutor doesn't like the case, generally the grand jury no true bills it. If the prosecutor likes the case, it gets true bill. I mean, it's not at this level a difficult feat to get an indictment if you want an indictment. The thing is that the prosecutor's office is not seeking an indictment.
No matter what those prosecuting attorneys do, they report to Bob McCulloch. Make no mistake about that.
If Mike Brown had killed Darren Wilson under the same circumstances, he'd already be locked up on a $500,000 cash-only bond, and his case would have been sent to the he would have been indicted by information, charged by information, and his case would have been sent to the grand jury for confirmation.